Those of the show personalities and guest alone, and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
And we are back. This is the Ask the Expert Show. We're with you every Thursday night from 6:30 to 7:30. We've had a slight time change. This is our 8th year with the Ask the Expert Show. And this is the last Thursday of the month. So that means Kay Bender Rimbaum. You can start calling now at 877-960-9960. We have a new phone number. It's 877-960-9960. That's our new number here. If you have a question for our guest tonight, Attorney Alan Swartzide, give us a call now. We're also looking at all your emails that have come in over the last couple of weeks, your text, and hopefully by the end of the show, you are going to be well versed on association law. Hey, thanks for hanging in there, Alan. I've got so many great questions for you tonight. It used to be, Alan, the pets. That was always number one, was about pets, wasn't it? Everybody wanted to know, but we rarely get questions about pets anymore.
Well, that's what happens when you have 2 hurricanes, a pandemic, and a building collapse in a matter of 3 years. I hate to be blunt, but I think that's pretty much where it comes from. We do get the pet questions, though.
Yes, we get those. So I'm going to go to Julie. She lives in Tequesta.
Okay.
Tequesta's north of Palm Beach.
Correct.
Actually, beautiful city. She says, I live in an HOA. And folks, please let us know if you're in an HOA or a condo, because it does make a difference. But she said, I live in an HOA. I have problems with my neighbor running his generator late at night. He plays loud music, which makes vibrations on the floor, which is why he got a generator due to his loud music. His generator runs all night. What can I do?
So there are 2 things you can do. One is you can report that to the HOA, who may go after that as kind of a nuisance violation. And when I say nuisance, I don't mean what a lot of people are thinking in respect to, well, it's no big deal, we'll just make it go away, which is what you consider a nuisance offer. In other words, here's $100. Now leave me alone. I'm not gonna deal with this lawsuit. What we're talking about here is something that interferes with the proper enjoyment of a neighboring property or the community as a whole. So when you talk about sound pollution and vibration of your own home, that's really what we're looking at here is a nuisance. And if you're in an HOA, you really need to look at the nuisance, not the news provision. I hope you don't have one of those. Look at the nuisance provision of your governing documents and determine, is this clear enough where it's actually a violation to do what this person's doing? I just came across a community that I just started representing in the last few weeks that had a really detailed nuisance provision. That's one of those that if it's not clear what constitutes a nuisance in your particular community, you'll want to consider amending it to make it really clear. These things are not allowed. Because usually it's really, and I hate the term amorphous, but I'll just say vague as to what actually is and isn't a nuisance. And keep in mind, in Florida, whoever's trying to enforce a provision of a contract is the one that's responsible for showing that it actually says what you're trying to say it says. So if someone couldn't possibly know because it's so vaguely worded that this was actually going to be considered a nuisance, a judge might be inclined to say, well, I'm not going to enforce it that way. So bottom line, I said there were two options. You can bring it to the association and hope that they enforce this as a nuisance, or you could come after your neighbor directly, which is frankly the preferred method, not involving the association and having all of the members of the community pay for what really only impacts your property. And you could go and frankly sue your neighbor to try and force them, maybe an injunction, possibly damages. But the bottom line is the easy way of addressing this, if you haven't already, is either walk over and knock on the door and have a quick chat, or if you're not comfortable doing that, send a quick letter and see if that does the trick. Now, if you've already done all those things, then it comes down to filing a formal complaint or submitting an email complaint, however you want to do it, with your association, or deciding to hire an attorney or go after a potential lawsuit on your own.
Here's Mark in Wilton Manor. He said, I know our association governing documents are critical, and we have 62 homes. How many homes do we need to vote to revitalize governing documents? I thought the vote was supposed to be done by a 32-unit vote when documents expired. Does that mean this vote was not valid? What can I do since attorneys are threatening, I guess, to us to pay the fines and dues?
Well, I hate to be the one to ever say this because 99% of our firm's clientele are community associations, but once those covenants expire and until they are revitalized, and the expiration, what we're talking about is after 30 years, the covenants, if they're not continued by a document or another process that gets recorded in the county public records, now it's as easy as having the board identify which documents they want to keep in place and recording something. But if that wasn't done after that 30 years after your original declaration was recorded in an HOA, those covenants can actually be expire and become unenforceable. So what you're looking at is if they're threatening to do things, they really can't threaten you with anything. And if they threaten you with it, they can't really push it forward. If they do, what you would bring up to a court as a defense to any enforcement action or any collection action is the expiration of these documents. So what you're saying is the association attempted to reincorporate all of those documents in the county public records and have them become enforceable again. I can't say whether or not that was done properly without looking at the documents, but I can say, generally speaking, you need more than half of the members to reinstate. There are other requirements that go really in depth. Deciding whether a Marketable Record Title Act revitalization was proper or not is something that requires a lot more analysis than I can give without the documents in front of me. But generally speaking, it is entirely possible if you have a 62 lot community that 32 lots was more than half of the members. If it was all done correctly, it is possible that those covenants were revitalized are now enforceable again, and that those threats are valid.
Alan, I went to a little college in Austin, Texas, called the University of Texas in Austin, and there were times I had no idea what my professors were saying. A compliment to you. You should be a law professor. You just make it so easy to understand. And I know that our listeners and viewers appreciate that. I want to go to Jackson and Pompano Beach. We don't. Okay, we're being told we have a caller. I don't see it on here, but we'll take your word for it. I hope it's my friend Barry. Barry? Is Barry there?
Yes, this is Barry.
Hey!
Can you hear me?
My buddy, I can hear you.
I am going to the University of Texas in Austin for the very first time in February.
You'll love Austin.
I look forward to it. So my question for Alan. Hi, Alan.
Hey, Barry. Good to hear from you.
Yeah, likewise. With regard to a phase one of the milestone inspection, Must a phase one include a visual inspection of the fire safety system, of the plumbing, and of the electrical systems?
The answer is a judge or the DBPR will let us know at some point. I, I think it might, based on the way that the statute is worded, and I know we've corresponded on this issue as well. I think it might. The answer is, candidly, I don't know. I think that based on the way that the statute is worded, it could be interpreted absolutely the way that you're suggesting. I think that to be safe, a cautious approach to avoid any potential violation of the new statute and the phase one inspection requirements, yeah, you probably should include that. I think that it's going to be difficult, frankly, even more difficult to get an engineer out and do that inspection than it would have been if that language weren't in the statute. But I do think that the statute could easily be read to require exactly what you're suggesting. I'd like to hear your thoughts on it, because you've actually been a fountain of information when it comes to everything involving this Senate bill.
Okay, well, I've spent 8 hours researching it today, and I don't know the answer to the question. So I talked to the Senate legislative staff. I talked to structural engineers. I think it is required, but I'm honestly, I'm not sure. But here's the problem. The structural engineers can't inspect those components. They don't generally, they don't have the expertise, and they'll tell you that they don't have the expertise to inspect electrical systems, fire safety, or plumbing. That you need an electrical engineer, a plumbing person, whatever. And if that is required, I think it's going to be, they're anticipating that a structural engineer come out and do the whole study. I think if they have to bring out several people to come out, you're going to have a bigger manpower shortage than you are currently going to have. So I think it has to be cleared up, but I can see that it's going to create a big nightmare.
I wholeheartedly agree. I mean, we've got time, but as I said earlier, and Barry, as you're aware, we've got the time, but we don't have the manpower, like you said, to try and get all this done within the next year. It's just not feasible for every community in Florida, every condo that might be subject to this legislation, to get all of this work done. I just don't see it as possible.
Right.
What I'm hoping is, I know that we've worked on a legislative fix, so to speak. I think next year what we might need to push is a substantive revision, not to the substance of the statute, because let's be realistic, that probably won't change, but to try and push back these dates to make it feasible to comply with what's being required of all of these condos throughout Florida.
You agree, Barry?
I agree.
Yes.
Thank you so much, and good
Thanks,
luck
Barry.
to you.
Hey, Happy New Year to you,
thanks.
too.
Thank you. Same to you. Bye.
I got to tell you, what can people do, Alan? I mean, can they write their legislators?
Absolutely. I mean, that's where all of this comes from. And candidly, I'm a member. Like I said, Allison Hertz of our firm is a member. Sean Brown of our firm out of Tampa is a member of the condominium committee of the Florida Bar. Most of our attorneys are, but we are some of the ones that are more active within the committee. I know that Mike Bender is active in CAI and several other organizations, but the Florida Bar Condo Committee has a little bit of pull. And so we're really pushing for it, but what the people can do, and I don't use that term derogatorily in any way, but what everyone that's not a lawyer involved in this field can do is exactly what you're suggesting. Write to your legislators and say, we are physically unable. We've reached out to 30 engineers. We've tried to comply with this, and we're getting dates of, and again, I'm hearing 3 months for any engineer. But I've heard of communities that are reaching out to people now a year in advance and being told, I can get to you in a year and a half. So absolutely, I think it's worthwhile to reach out to your legislators and explain that complying with this new statute may not be feasible.
We have Veronica in Fort Lauderdale. She has a concern, Alan, about the board being able to just walk into her unit without any permission at all.
Well, the permission, and when you say unit, I'm presuming we're talking about a condo here, because in an
Yes.
HOA, that would have to be in the governing documents. Otherwise, the board has no right technically to enter a unit except in emergency situations. In a condo, there is actually a statute that specifically says that the board has the right, after reasonable notice, to enter into a unit. So you may think they have no permission, and the fact that you didn't personally give them permission directly, you did by owning a unit in a condo, by virtue of that statute. So the statute basically says the association has the right to enter into a unit upon reasonable notice to basically protect the common elements or other units. So if they have reason to believe that something in your unit is going to damage other units, or they think something, for example, is running through the pipes or the air conditioning system throughout the building that's going to damage other common elements or other units, they do generally have that right to just go ahead and enter into your unit. Again, after reasonable notice. Your note points out that that may not be what happened here. So they may have known they had to write, but not known that they had to notify you in advance. Now, the difference is if there's a true emergency, they generally will have the right to enter into your unit and try and resolve it. That's usually going to be there's water leaking and it is running through your unit into another one or behind or around your unit. They don't have the right to just barge in, I'll put it that way, but they do have a general right to enter in and protect the common elements and protect the other units within the condo.
You know, Alan, I hope I got this wrong, but I heard somewhere, and it could have been a whole nother state, that they're going to stop doing criminal backgrounds on renters. Have you heard that?
I've heard of it. It's not necessarily something that's passed, but what is in place in Florida and frankly in most states at this point, if not all, is a limitation on how you can use those criminal background checks. So there's case law that has come out that basically says unless you're using it for specific purposes, in other words, basically that criminal background check is pretty much useless unless you find something in there that shows that this person is going to have a violent tendency to cause real problems in the community. The financial aspects of criminal background checks probably aren't going to help. Where it might help is, if you've got someone that is coming into the community and trying to get on the board, because that's one of the limitations. If you've got a felony on your record and you haven't been had your rights restored, your civil rights restored for at least 5 years, you're not eligible to sit on the board. But when it comes to just renting, like you mentioned, there's almost nothing that the association can actually use in determining whether to allow for that rental or not. More often than not, it's something that the board wants to know who they're letting in, but they can't necessarily control who they're letting in. But what they can do is be aware to look out for certain behavior. So you can run the background check, but the information you can actually use as a basis to reject a potential tenant is minimal at best.
We have Laura in Palm Beach. She wants to know, our board wants to combine the annual board meeting with the budget meeting. Can they do that?
I don't have a huge issue with it. The problem is, as a practical matter, you've got the board coming in and either immediately having to approve the budget without having been involved in the budgeting process, or you have the board approving the budget and then immediately stepping off and having no responsibility for implementing it. Now, of course, we've got directors who carry over, directors who were involved, but generally speaking, I don't think it's a good idea. I'm not aware of an express prohibition on doing it that way, but I think it's probably a bad call.
No, we had pandemic questions, not like we used to. But here's one that said, does the CDC have control over the rules at condos?
No, but if the condo association as a corporate entity, because keep in mind what we're talking about here is a business. That condo association is incorporated for a reason. You're running a business if you're on the board. So for that business, that corporation to be protected under Florida's fairly recent COVID related statutes that say if you do XYZ, someone can't sue you if they can track COVID at your facility. In order to be protected by that, you need to be following and having protocols from some governmental agency. The CDC is one of them. So the CDC can't tell you you need to shut down unless there's some kind of outbreak of something probably other than COVID going on. But what they can do is implement the restrictions that they would recommend. They can implement recommendations. And if you follow those recommendations, you're protected from liability for certain lawsuits related to COVID. So they can't come in and say, you got to shut down your pool because of COVID. But they can say, well, if you don't shut down your pool because of COVID and you get sued because someone got it in your pool, you're not protected by the statute.
Here's another COVID-related question. This is from Paul at Royal Palm. I guess they're a 55-plus community. She said, we were supposed to have our annual meeting, but we couldn't because of COVID. We got sued by the residents because we couldn't have a meeting. Can they really do that, and can they all?
Well, here's the answer to the recall question. Absolutely, because you can recall directors for any reason, including a bad reason. There is no you did wrong, so you're being recalled. It's we got enough votes, so you're being recalled. So the answer to that one is absolutely. I think it's a bad idea to do it for that reason, but it's an option. But when it comes to the meeting, can they sue for failure to have the meeting? You know, you chose not to have the meeting because of COVID. It's not that you weren't allowed to. You may have had restrictions that you needed to implement and follow, but there were people that were doing virtual meetings and having their elections that way, and that comes with its own host of problems. There were people that were doing, I know of a community in Kissimmee that did its election in an open field so that they could have social distancing in place. But they still had the election meeting and everything was fine. So, you know, I think that there is a defense to that lawsuit that you were doing what you reasonably believed was in the best interest of the community and the members of the community by not putting them in a position where they were at more risk just so that they could vote on your election. So the answer is, yeah, you can be sued for it. The question is, what are they trying to get out of that lawsuit? Force you to hold an election? I just don't know what the basis or the purpose of the lawsuit would be. And when we're this close to election season again, you know, it's 55 and over. I get that. You're still concerned, and you frankly should be, that you're putting people at risk by putting them all in the same room, but do it in a field. I mean, the community in Kissimmee I mentioned, they had it on a soccer field so that everyone, and they put speakers up so that everyone could hear what was going on, everyone could see what was going on. That might be the type of thing you have to do. Maybe not in this cold weather we're having lately,
Yeah.
but in general.
Alan, I wish you saw how many questions I have here from listeners. Great job tonight. I can't wait for you to come back.
I'm looking forward to it.
Give everybody the phone number. Not in Orlando. You have a toll-free number for all the locations.
Yeah, we have 800-974-0680. That's to reach any one of our offices. And like you mentioned earlier, we've got the two fantastic ladies working up at the front desk in Pompano. They take every call that comes through our office, and they'll route it to the right person.
Also sweet, too. Anyhow, thank you so much, Attorney Alan Swartzide. And I can't thank you enough. Did a great job tonight. We'll see you down the road.
All right. Do you mind 30 seconds of self-promotion real quick? We got
Go
one
for
event. All right. So we've got funding construction projects coming up January 11th with Mike Bender live in South Florida. That'll be in person. I've got covenant enforceability for HOAs and condos that I'll be teaching via Zoom on January 12th. We got a condo board member certification January 17th. That's being taught by Allison Hertz. That'll also, I believe, be via Zoom. We got the legal update on January 18th, live at Capriccio's, again, Mike Bender in South Florida. And finally, for January 26th, I'm teaching an HOA board member certification via Zoom on the 26th at 10 a.m. Thank you for that.
I didn't know you had those with you. Very good. Thanks again, Alan, and we will see you all next time.
Thank you very much.
Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
WWNN AM Pompano Beach, WIRK HD3 Indiantown. Programming paid for by Vic Canales Media Group. Broadcasting live from the Robes Studio. Injured recently? Call the Robes Law Group, where winning is a habit. 561-570-5700. 561-570-5700. Robes, winning for you and our community. This is the one and only.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
Where we bring you the experts here in South Florida that specialize in legal, health, financial, and home improvement. And for those of you who call into our show with your questions, we have a new number tonight. It's 877-960-9960. That's 877-960-9960. This is the last Thursday of the month, which means K. Bender Rembaum. They are an association law firm that has been with us for going on 6 years now. They're with us the first Thursday of the month and the last Thursday of the month. And tonight we have a special guest from the firm. We have attorney Alan Swartzide. Please tell me I pronounced that right, Alan.
You got it. Well done. I'm proud of you.
Hey, if you saw my last name, you'd wonder I'll get anything right. So, Alan, is this your first time or second time with us?
First time. So long story short, I was with K. Bender Rembaum from 2010 to 14, and I just rejoined the firm about 4 months ago.
I got to tell you, we get calls. Probably I get 3 or 4 calls a week, every single week, from other attorneys who practice association law, and every single one of them, Alan, says what a great law firm K. Bender is. And I better say Rembaum, he will Jeff will definitely get upset with me. But you know how it is, like when your peers, there's always someone who's going to go, oh, they're no good. But I have never, with all the calls we get from law firms, no one has ever said anything negative about K. Bender Rembaum.
I can't say that surprises me. I mean, frankly, that's why I rejoined the firm. If I didn't really respect everyone that's in charge of the firm, and frankly, it's nice. Most of the people that I was working with the first time around, they're still there. We've got many attorneys, many paralegals who've been with the firm for 10, 20 years. So I wholeheartedly agree. Again, if it wasn't for the fact that the firm has this stellar reputation and the fact that it's well earned, I wouldn't be there.
I got to tell you, because we work with a lot of firms across the country and our other markets, and I come up to your office probably about once every 2 months. It doesn't matter what time of day I get there. There's always 2 girls out front. So customer service is very important at K. Bender Rembaum.
It is. I mean, I personally, and I know that there are many other attorneys within the firm that have my own internal policy when it comes to customer service, especially if it's a client, they're going to hear back from me within less than 24 hours. And I may not have a substantive answer and say, well, it's a yes or a no within those 24 hours, but I'm at least going to acknowledge. And I find that that's a big difference between, our firm and a lot of other firms out there when it comes to that customer service, of just saying, listen, I'm here for you. I'm not ignoring you. I'm not, deferring you because someone else is more important. I got you covered. I think that one little step makes a big difference in the way that people are perceived. And I think that it's fantastic that we do have, two people that are always available. We've got multiple offices. So anywhere in Florida that needs to be serviced, we've got it covered. But I do agree, customer service really comes to the forefront, other than, of course, the legal knowledge when it comes to talking about our firm.
Well, the ones that talk negative always say, oh, I left a message at the firm and I get a call back 6 days later. And usually when your client needs to talk to you, listen, it's almost impossible to be able to get back with them within an hour, but you sure do try. And I've never heard anybody wait longer than a 24-hour period.
Yeah, I appreciate hearing that, because I think that it is something important, and it's something that we do really put to the forefront, that, our clients are extremely important to us. We're not just sitting here trying to bring in as much business as we can. We're trying to make sure that we really are servicing every single client as though they're the only one out there.
Well, I got to tell you, Kay Bender Rimbaum is such a great friend to this show. And if you're tuning in for the first time, because we're on 6 stations, and I've been doing this for 12 years. I've never had a radio station that had 6 of their stations at the same time simulcasting the show, but this station does it. So we have 2 ways that people can talk to you, ask questions. One is you can call us. This is the new number. I'm kind of surprised we just got it just now, but it's 877-960-9960. That's 877-960-9960 if you have a question for Attorney Alan Swartzide. Do I say board certified?
No, not yet. Haven't had the opportunity to push that forward until I rejoin the firm. So
I totally understand.
Can't make any comments, but my guess is sometime in 2024, that'll be on my email signature.
Beautiful. Well, listen, if you're at Kay Bender Rimbaum, you've got to be good at what you do. So another way is we have people text and email us questions. A lot of people don't want to go on the air. Why? I have no idea. So we have a lot of questions tonight. But if you have a question that has to do with HOA, condo association law, if you're a board member, if you are with a management company, or you're a resident at a community and you have a question, now is the best time. Again, call us at 877-960-9960, and we're going to get right to the questions right away, Alan. We're going to start off with Brooke in Coral Springs, my old stomping grounds. Brooke wants to know, what is the state of condominiums here in South Florida? Have they been given any recommendations? Isn't there a grand jury looking at that now? I haven't heard this.
Well, I think what you're probably referring to is what happened in Surfside, the tragedy that occurred I think it was about a year and a half ago. And there are certainly statutes that have come about over the last year. Myself, as well as another member of our firm, Allison Hertz, are both on the task force to try and kind of clean up the statute with a lot of technical glitches that we're trying to get rid of. But to get back to answering the question, there's not anything that I'm aware of with respect to a grand jury. There was a lawsuit that's been settled with respect to that Surfside building collapse. There's a lot of legislation that's come about since that. There are now, many requirements. It's Senate Bill 4D that turned into law that it is a litany. We wouldn't have time within the hour that I believe we have today to go through everything that this bill requires, but it's basically more inspections, action actually being taken once those inspections disclose a problem, as well as a lot of reserves that weren't required before, but are being required now. So that's I believe that's what you're referring to.
Probably is. Alan, I'm going to ask you a question I've been asking all the attorneys from K. Bender Rimbaum. I am inundated with emails from senior citizens who own a condo or an HOA. They're nervous, Alan. They're nervous in regards to their homeowner's insurance, because a lot of insurance companies are going out under, and the ones that are still there are doing nothing but raising their rates. And then we've got this, speaking of Surfside, there's going to be these architects and engineers, anything 3 floors or higher. Well, guess who's going to pay for that? And we're talking millions, right?
We're talking multi-millions when it comes to almost every single one of these repairs, replacements that might be required. So absolutely. I mean, the insurance industry is 100% related to what you're talking about here. There is a legislative session that I believe is still going on where insurance is specifically being discussed. But I'll be candid. I mean, I would be concerned as well if I were a senior citizen, especially one that's on a fixed income and is concerned that that fixed income may no longer cover the expenses of that condominium. It might turn into you need to move. I hate to be blunt, but you may not be able to afford to live in a condo. It may be a situation where all of these elderly people need to find townhomes or smaller condos that are not of that height or are not located near the beach, because those are the ones that are really being targeted by the new legislation. But I'm hoping that there will be some relief provided to homeowners via this insurance bill that's being contemplated now. I'm certainly not going to make any promises because we saw how Senate Bill 4D played out over the last year. And that definitely, I think it benefited homeowners, it benefited the condo owners, including those elderly people who would have been in a building like Surfside that might collapse. We've seen several of those buildings in Miami in particular that have been condemned and have had, the residents, the members, had to move out until everything was deemed safe again since the Surfside collapse. So I'm glad that safety issue is being contemplated. Unfortunately, I fully agree. The cost of not only doing the necessary repairs, but the cost of insuring those problematic things. I mean, I can definitely foresee that the insurance companies are going to require those inspection reports before they're willing to insure any units within a condominium that's required to have one. So I'm hoping that the legislature, having done what it did to require homeowners, condo unit owners in particular, to go out and spend all this money, is also going to give the benefit of saying, yes, you can require X, Y, and Z with respect to homeowners insurance, but maybe we'll have the government kick in some funds. I'm not really in favor of that in general, but with the amount of elderly individuals that are on that fixed income, especially in South Florida, which is where, by the way, I grew up. I'm in Central Florida now. I run the firm's Orlando office, but I grew up in South Florida from the time I was 12 until 2018. So, I've got South Florida in my blood, and I understand the issues that all these people are facing. All I can say is, it's a frightening time.
Yeah, you know what they're really worried about? And I hate to say this, but it's out there. They're worried about having to live in their cars. That's how sad it's gotten.
Yeah, I agree. I mean, unfortunately, what I will say is what I've said earlier. If that is a possibility and you're worried that, another $500 a month to cover the cost of all these necessary repairs is not something you can afford, whether you're elderly or not. I mean, that is definitely something that could easily impact most people in Florida. And $500 a month is not an unreasonable figure to expect if you're in one of those coastal buildings that is going to be subject to these new assessments and potentially increased insurance premiums. It may be time to start rethinking where you're residing. I'm certainly not trying to create a panic, but you need to look at your reality and your future and decide, do I want to get out now, or when it's frankly even harder to live in one of these buildings that you might not be able to afford. What you're also going to see as a result of a lot of these assessments that need to be levied is unfortunately a lot more foreclosures. And it's not going to be the banks necessarily that are foreclosing. It's going to be the communities.
Yeah, that's correct. And I got to say, we get so many letters because your show is so hot. We get so many letters, and what it seems, I understand everything, the cost of everything is going up. Food's going up. People's salaries going up. But it seems like there's properties out there that are raising their rates, but what they're doing is they're upgrading nicer food. They're making restaurants nicer. I mean, those are things that don't necessarily have to be done now, but they are doing it. And that's why people are worried.
Well, there are two ways to look at that. When you're talking about a community association, a country club, a condo that's offering those types of amenities, what you're looking at is not only, I understand what you're saying, I'd be concerned with that too, but the other side of that coin is you also need to be concerned that all of the other communities out there that you're competing with for membership, that you're competing with for homeowners, and candidly, my earlier comments, I don't know what kind of blowback I'm going to get from the people that don't want to hear it's going to be harder to buy, it's going to be harder to sell. But the reality is you've got that competition, especially in South Florida, for, which country club is the most prestigious one in Boca? Which is the most prestigious in Miami? That's the one I want to be in. So when you're not accommodating for, the lobster instead of burgers, you tend to be looked at as lesser than. And I hate to say that is something that goes on, but it's a constant battle. I know my parents were in a country club. They're in a different one now, but they looked at, when they were looking at where to buy and where to reside and who to be affiliated with and associated with, they were looking at the reputations of these country clubs and what amenities were offered. The other thing is most of them, to be candid, they're not trying to make a profit as a country club. They're not trying to cover their expenses when they charge you these rates for the food and drink that they're putting out. They're trying to get people in the door. They're trying to get people to buy into the country club. And so it may be that all they're trying to do is not show off, but to show off, if that makes sense. They're not
totally understand.
They're saying, let's go out and spend all this money needlessly. They're saying this is a marketing tactic and we need to do it or we won't survive.
Hey, Alan, I think you and I ought to go to school and become an engineer. There's going to be a shortage of engineers.
Oh, yeah. Well, there already is. I mean, there are many communities that are already looking into, yes, the requirements of that statute that I mentioned earlier and the Senate Bill 4D that is now law. There are requirements that don't kick in until the end of next year. Actually, I say next year, but we're a couple days away from 2023. It's really the end of 2024. But what people are looking at is, there's not going to be enough engineers out there to have these inspections performed once this kicks in and people are actually scrambling to get it done. I wholeheartedly agree with you. We're already in a situation where I've got clients that are having difficulty finding someone to come out within 3 months and inspect their buildings.
We're going to go to break right now. Do you have the phone number by you? The toll-free number?
Do I?
Do you have the toll-free number there?
I don't.
Okay. I know you don't call yourself.
Oh, does the firm?
The firm.
I know we do. I don't know it by hand. We got 888-404-1010. We've got 800-974-0680. Let me repeat that one. 800-974-0680.
We're going to go to break. We're here with attorney Alan Swartzide, K. Bender Rimbaum, our favorite law firm. We're going to go to break. We'll be right back with more association law.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert Show. We're with you every Thursday from 6:30 to 7:30. And we have some of the finest law firms, doctors, financial people. And this is the last Thursday of the month. So that means K. Bender Rimbaum. And we're talking about association law. If you live in an association and you have a question for Attorney Alan Swartzide, you can call us right now at 877-960-9960. That is a new phone number, 877-960-9960. The old number we've had for probably the last 8 years is no good anymore. We were told tonight the new number. Can you believe that? Right before the show. Anyhow, we also have questions that people have sent in, and we're going to go through those with Alan. Again, if you have a question for Alan, give us a call at 877-960-9960. Alan, let's go to the next question. This is from Dr. Daniel. He's in Davie. He wants to know, is there a condo law as to how many handicap parking spaces there can be in a community?
Well, the way that the question is asked, is there a limitation on how many there can be? Nope, there is not. There's no specific condo law as to how many there need to be. But there are other laws, federal laws, and also state laws that will govern how many you really need. And that's frankly going to be dependent on how many people in your community might need those spaces. If you've got 10 people residing in your condo that need a handicap space, they've got the placard, they've got whatever they need, they've shown you the placard, and you have 5 spaces, you'll probably need to create 5 more and possibly more than that, because anyone that's coming in to potentially purchase or rent a unit in your condo is also going to need to have access to one of those spaces. So there's no magic number. It's the right amount is the right amount. But to answer the specific question, though, there's no limitation, and there's also no minimum in the Florida statutes in Chapter 718.
Wouldn't those numbers change every year? More people moving in, people moving out?
Potentially, and usually what the condos will do is if you've got a glut of those handicap spaces that are not being used, you can consider kind of transferring them back to be regular member spaces. If you don't have enough, you may need to figure out a solution to add handicap spaces. But yeah, it can fluctuate as people move in and out. And unfortunately, you might be stuck in a situation where, in order to accommodate people that need those spaces, you really are required by law to do what is necessary and make sure that everyone that needs one has one.
There is, I'm pretty sure they have an association, and there are not enough parking spaces. And here's the reason why. There's people who are only supposed to have one parking space, but they bring 2 cars in with them from New York or from wherever. Can anything be done about that?
2 different answers depending on what your governing documents say. If your governing documents treat those parking spaces as what's called a limited common element, meaning that it's attributable to one particular unit, one particular lot in your community, then you're probably stuck with those individual spots being pretty much owned by the person that owns that unit or that lot. But if they're taking up a second spot, I literally just spoke with someone about this yesterday that I was helping out, another attorney that's a friend of mine. The bottom line is, if they're using extra spots, you could put a rule in place within your community that governs how those spots are allowed or supposed to be filled. And if you've got the authority, you might be able to have a towing company come in and take out the cars that are parked in the wrong way. This is one that I would highly recommend you run by your attorney before you even think about implementing this type of rule, because it is such a challengeable issue that, well, did you pass the rule correctly? Are you implementing it correctly? Are you implementing it uniformly and consistently across the board? Or are you just basically saying, well, you guys are using 2 spots, so we're going to kick you out of one of them? But bottom line, if you don't have enough spots, then you need to either create more somehow or figure out a way that people can park off-site. And again, going back to the previous question, if you don't have enough spots, and some of them are for handicapped individuals who have those placards, have requested an accommodation, those you really need to accommodate, because you don't want to mess with the Americans with Disabilities Act, because what you might end up in is a lawsuit against the association where you can't recover your attorney's fees and costs, and those can be in the tens of thousands.
Alan, we're going to ask you to hold on. We're going to go to break right now, and we're going to say goodbye to our 6 to 6:30 crowd. We're going to go to break. We come back. We will have more with Alan. K. Bender Rimbaum. We'll be right back.